Lawsome by ConsultWebs. Breakthrough insights to build a thriving law firm with your host, Tanner Jones.
Hello, everyone. Today on our show, we have Dan Callahan, former president and managing partner of Callahan Blaine, a trial practice that has achieved consistent success for its clients now for over 37 years. Dan is now the owner of Callahan Consulting Group, a new venture he started that provides consulting services to California-based law firms about litigation and trial strategies. Callahan Consulting also provides case matching services where he pairs clients with the best firm for their particular case in their area. Dan, you're known for being a fierce litigator and winning the impossible case. Really excited to dive into how you've accomplished such success over the years, so welcome to the show.
Tanner, thank you very much. It's my pleasure to be here.
What got you originally interested in the world of litigation to begin with? What sparked that passion?
Well, this will reflect my age a little bit, but I used to watch Perry Mason with the family. So I wanted to become a lawyer. My mother said I'd make an excellent attorney, so that was always in the back of my mind. However, I didn't really do that well in high school, so I went and worked construction. And after a couple of years, I thought, what am I doing this for? I can be a good lawyer. So what I did is I thought I'd really work hard and prepare, because now I'm going to go against all those smart kids from high school. Well, as it turns out, when you prepare really hard and you're preparing to fight the opponent like Goliath, you put him on a pedestal, well, it turns out they're really not Goliath. So I went through college with straight A's. I had a similar result in law school. But even to this day, whenever I'm up against somebody, I tend to put them on a pedestal and I prepare for the biggest and baddest. Usually they're not the biggest and baddest, so I do quite well. It's all about preparation.
Love that, and I want to explore that a little bit further here in a moment. But I want to kind of speak to where you are now. You've evolved. Obviously, you've built a tremendous career and reputation in trial practice and handling serious, very complex cases in many instances. But you've also gravitated in more of a mentorship role. You're a mentor for attorneys, helping them find success in their own paths. So what would you say is the most common piece of advice that you find yourself offering those types of attorneys in that mentor relationship?
Well, you're right, Tanner. I do mentor attorneys in my law firm. We have 28 attorneys, and I'm the lead trial lawyer. But I also mentor other lawyers in the community by doing seminars. And the best advice that I can give is preparation. I keep stressing preparation. You have to do everything to the best of your ability. And also, you need to be creative. You have to think outside of the box. If I may give you an example of thinking outside of the box. Now, these are not a couple of my big verdicts, but I'll give you a funny example. I represented a customer who sold goods to a construction site. But he was from Arizona, not California. He wasn't paid. And I said, well, did you do the mandatory 20-day notice to perfect a mechanic lien? He said, no. I said, well, can you go to the site and get those barrels and drive them around the block and then drop them off again and then do a 20-day notice after you've released possession? He said, no, they're locked up in a warehouse. So I thought about it and I realized he told me the subcontractor bought the goods on credit. So I did research, and if you sell goods under the UCC to someone on credit while they're insolvent, you can reclaim those goods and get constructive possession, although the goods never leave the warehouse. So we reclaimed the goods, got constructive possession, wrote them a letter back releasing the goods, and then served a 20-day notice. The other side kind of said that was ridiculous, but the presiding judge agreed with me, and the other side had to pay for those goods twice. That's being creative. I just attached the UCC to mechanic lien law. I have so many examples, but I think creativity, you should just not go lockstep through the CCP. You should think outside the box. Let your mind go a little bit. Well, how can you accomplish the objective for your client? Creativity is the best way to do it.
I love that. Fascinating. Good example too. And I want to, let's come back to that concept of, facing Goliath. And really anticipating your opponent being bigger, maybe more, financially backed. Maybe they have the facts in their favor. Whatever that may be, positioning it early from a mental standpoint that they're going to be bigger and stronger. I can understand, at least I can interpret that as being, well, really what you're doing is you're setting yourself up to over prepare, to ensure that you're going to, you're prepared for anything they throw at you, uh, compared to the opposite of that being under prepared. Would you agree with that concept, that it's over preparation that you're aiming for?
I don't think it's over preparation. I think it's total preparation. An example of that is a case I had, Beckman Coulter versus Flextronics, two multi-billion dollar companies. And we represented Beckman Coulter. Flextronics was represented by a very large law firm, very good. I prepared endlessly for that case. What I do to prepare, which everybody should do, is go into a lockdown mode, get all the depositions in your office, read them yourself, summarize them, prepare the examinations yourself, link them with all the exhibits, prepare your own opening statement, practice a few times before you go into court, and then also do your voir dire. Understand what's the proper way to get the best jury for your case. So we had a $2 million breach of contract case, and I had prepared everybody's examinations in advance. It turns out that I discovered a fraud in discovery, a $300,000 fraud. We go to trial. The offers they were giving us were negligible, and so we went, and 7 weeks into a 3-month jury trial, I amended the complaint to add 2 more causes of action based on evidence I'd already solicited. That was for economic duress. The jury came back unanimous. They gave me the $2 million breach of contract, the $300,000 fraud, plus $1.25 million in punitive damages. And on the last 2 causes of action that I added 7 weeks into the trial, they gave me $180 million in punitive damages on one theory and $750 million in punitive damages on the other. That came from preparation. And so I'm such a believer in being original, being creative, being prepared. And if you are that, you're going to feel like the 800-pound gorilla. If you have not done all of your work, in the back of your mind, it's going to be, geez, I hope this doesn't come up. And you should do examinations in advance, because if something does come up on a Tuesday and you can go back to the office and work on it, then you have the opportunity. But if you go back to the office saying, well, I have to prepare for these 2 witnesses that are coming up tomorrow, you should have done that beforehand. You should leave yourself some slack. Let me give you another example. I represented a large Japanese subsidiary, and they're accused of discriminating based on national origin in favor of Japanese. The counsel who had the case before me admitted that they did. But he said, we're protected by the U.S.-Japan Treaty. The judge correctly pointed out that an American subsidiary is not so protected. So the company changed attorneys, gave it to me about 2 months before the trial. We prepared, got it ready, and because I did it my way, when the witness who said he was being discriminated against talked about his emotional distress, he said he felt like he was in a white room with no doors or windows. And I thought, wait a minute, I've heard that before. I know I have. And it was on Twilight Zone. So I got all the jackets for the DVRs, the videos, and I found it. There it was. So when I came back in on the Monday following, I asked him, excuse me, now when we left off on Friday, you said you suffered emotional distress, and the jury can see I have something in my hand. And you said you felt like you were in a white room with no doors or windows. Is that right? Yes, that's right. Well, geez, that's the same thing it says on this jacket for the Twilight Zone. Are you a big Twilight Zone fan? Well, anyway, the jury went crazy. It's a really bonding exercise. But if I had to work on preparing for the next witness, I would not have been able to devote the time to get that information and evidence. So being in trial is being a showman. And you can be a showman when you're prepared.
Dan, I would say that, obviously through your successful career, you've had quite a few experiences that have shaped you. Would you say that's accurate?
I guess I would say that's accurate.
I think we all have moments in life where, looking back, you can see a before and after period, a transformational moment, if you will. What's one of the biggest personal life or career transformational moments that you've experienced?
When I decided to go to college, after not doing so well in high school, but I decided to go to college, I wanted to become a lawyer. That was a transformational point. And I thought, I'm just going to have to prepare. I'm going to have to work really hard, do everything I can do to beat what I perceived to be an opponent who may be more well-equipped, smarter than I am. So I prepared to beat Goliath. And I do that every time. When I did it in college, I had straight A's. Then I went to law school. So, okay, Dan, you're pretty good at college, but this is law school. These are really smart guys. So I did the same thing with a similar result. When I became a lawyer, I said, okay, Dan, turns out you're pretty good at school. But now this is law. These guys have been practicing for 5 and 10 and 20 years. So again, they're on a pedestal, and I come for them. So that is the biggest change in my life. It's changing to learn how to prepare, fully and totally prepare, and be willing to do whatever it takes. Don't put off till tomorrow what you can do today, because tomorrow some other thing may come up, and now you don't have the time to do the full best job you can. And the way you can tell a really good lawyer is somebody who is prepared. He communicates well with a client. He has originality in thought. He thinks outside of the box and is prepared to do whatever it takes to win. If you have somebody, on the other hand, that thinks, well, I'll just do enough to get by, well, they can get by somewhere else. You don't win by just doing enough to get by. And I think Ben Franklin said, if you're not preparing to win, you're preparing to fail. So I guess the theme here is preparation.
These types of moments, these transformational moments, often the clarity comes after the fact, right? Because it's difficult in the moment, especially when the stress is up. You've positioned yourself, as you've described, mentally, of looking up to the competitor or to the opponent so that it ultimately drives you forward. But taking all that into consideration, these moments often cause pain. Growth can be painful, right? I mean, the whole process of not just your own business growth, but your personal growth, it can often be painful. It can be tough, just as you said, hard work is often what has led you to where you're at today. I'm curious to dig into your process, specifically in handling cases or preparing for cases, because you've made a very strong point around the importance of preparation. So can you offer our listeners maybe an inside look into how your process has personally evolved in handling cases over the years?
One of my partners says, the harder I work, the luckier I get. And I've given up many, many weekends. I remember during that one trial with Beckman Coulter, driving home on the 4th of July when all the fireworks are going off. I was not taking that day off. I was working. So the pain I went through is the pain of depriving myself of certain things I would have loved to done. However, it's overshadowed by the feeling of high-fiving your winners. You have your partners and you celebrate. All the pain you went through to get there is immediately forgotten when you are celebrating a big win. So again, work and work hard.
And it takes discipline in that as well.
It does take discipline.
And I know you often, when you're preparing for big cases, you'll go into self-isolation. Is that right?
Right.
Can you speak to that?
Yes. Well, I do. I go in what's called a lockdown mode. And this is where I mentioned earlier, I will bring all the depositions in. So let's say that I'm not the one who took the depositions. There's another attorney that did so. He will point out which depositions to read first. I will read them first, and then I'll read all of the depositions. I'll summarize them. I'll prepare all the examinations, and I'll do all the jury instructions, opening statements, you name it. So that is in the isolation or lockdown mode. But I got to tell you, one of the reasons I do that is fear. When I first get into this, I go, oh my God, like what, circuit boards? I don't know anything about circuit boards. So now I have to learn. And I drive myself to learn the subject matter of each client's case. And when you do that, in part, I just don't want to be embarrassed by not knowing something. But so I have a fear of not doing it correctly and getting a bad result and being responsible for it. So I guess fear in part drives me.
And that discipline we've talked about has clearly, at least from a public-facing standpoint, has clearly led you to really take care of a lot of important things or aspects related to your business and your own personal growth. One of those, I would say, would be in the area of of marketing. I came across there was a tagline there on your Callahan Consulting website that mentioned when Dan Callahan was told he needed to play the marketing game by having his own YouTube channel. As he saw it, he had two choices. He could join the army of crusty lawyers in crusty suits saying crusty things, or he could go to the next level. Which one did he choose?
Well, not the crusty one. So I was fortunate by having some friends that know YouTube and how to go ahead and present me in a different way. So if you go to my YouTube channel or go to callahanconsulting.com, you'll see my website, but also there's links to videos. So the first group of videos has a 1-minute intro with a jet plane and me with a machine gun and all kinds of things. The second one is a 2-minute intro, and that's Mission Impossible with various scenes out of Mission Impossible. And after that, it goes into a 5 or 6-minute summary of the law in different areas. That's fun. That was really fun. But I've been into marketing for quite some time. I started out, and I think your listeners should try to do this. You have to have your name out there, right? So I wrote an article called "It's the Law" for the Orange County Business Journal, so people would see the name Dan Callahan. Then I put together seminars, and I get all the leading trial lawyers, and then I put myself on the panel, even though I hadn't had a trial yet. But they figured, well, this is a big shot. This is a big shot. Well, I guess he must be a big shot. He must be good. He's a panelist, right? And that allowed me to get hired then to handle some trials. I learned from some of the best, and I've adopted some of my own things, but that marketing will help you develop. I also, of course, now, as you mentioned, YouTube, and primarily it's writing articles, speaking at seminars, and then meeting people. Get out. Don't just stay in your office. If there's an event in your local community, get out there, meet people, pass out cards. You know, you have to be a good lawyer to win a case, but you got to get the case before you can win it. So you got to get out there, let your name be known. And if your name is known, then when they think, who do I need for a lawyer? You want your name to pop up in their head, right? So I also advertise in the Orange County Business Journal every other week, and I do various things like I'm doing right now today. I want my name to pop up.
Agreed. And you've done that extraordinarily well. Have you what would be the impact? Looking back, what has been the impact on taking the initiative, having the discipline to not only invest money, but time and creativity into your own marketing?
Well, that's what has allowed me to get the cases that I've gotten. That's what allowed me to build a firm with 28 attorneys. And it's getting out there and doing the work. So my job is I'm a trial lawyer, but I'm also the managing partner, and I'm also the person that brings in most of the business. You know, often you have somebody who does one or two of those things, not usually three. But if you're a new lawyer and you're going to go out on your own, you have to do all of that. You have to bring in the business, you go ahead and manage the firm, and you have to try the cases.
There's a lot to learn from you here, especially, I mean, you mentioned the young lawyer. To the young lawyer, or maybe with the amount of experience you have, I would suspect that a lot of the listeners have less experience than you do. And so, there's a lot we can learn from this dialogue. And I'm curious to know, from the years of practicing law, the years of growing and nurturing other attorneys under you, the years of consulting other lawyers outside of your own law firm, I'm sure you've been able to identify strong players and the not so strong ones in the legal profession. Can you speak to, let's start with the strong ones. What are 3 characteristics that you've identified consistently in the strong players and the strong lawyers, even at a young age?
Well, one that I haven't mentioned yet is active communication with your client, right? Don't run and hide from your client. You should be able to bring them up to speed at all times. They're paying you, to represent them. And they have a certain uncertainty because they're involved in litigation and they don't know how it's going to go. They're not in that field of litigation. So you need to communicate clearly and positively to your clients. Then you also, of course, we're back to preparation, we're back to creativity. Those are the 3 things: communication, creativity, and diligence and preparation. Those are the hallmarks of a good attorney. Someone who doesn't communicate with the client, leaves the client wondering what's going on. The client may want to switch law firms because they're not getting the information they need. And especially if this person doesn't do everything immediately and they put it off and they put it off and they put it off, that's not what you want. As I mentioned earlier, if someone puts something off from today they could be doing, you don't know what's coming tomorrow. And your tomorrow may be full and you may not be able to do your best job. So just do everything you think you should do to win, right? If you know in the back of your mind, I really should be doing this today, then you should do it.
Dan, we are grateful, very, very grateful for the wisdom you've been willing to share with our listeners. I'm curious to hear, is there anything that I should have asked or that you would have wanted me to ask you in this conversation?
Remember the think outside the box? I had a case where these two women were hit by an uninsured drunk driver, hit and run driver. He actually was sentenced to 4 years in prison. Different lawyers looked at the case and they turned it down because the defendant would have been, in jail with no money. I took the case and I sued not the driver. I sued the city of Dana Point for improper road design. These girls were jogging in the bike lane. Normally a bike lane by statute is approximately 5 feet wide. This was 11 feet wide. I went out to the site and I noticed that this bike lane is 11 feet wide. So I researched how wide is it supposed to be. And I realized that may have been the reason that, in fact, it turned out that was the reason that the person testified. He was behind a truck. He looked to his right. There's nobody in the right lane, but that was a bike lane. And he moved over and he clipped these two girls. I then realized that and saw what the law was. I sued the city and I discovered that they had been told previously that that was a dangerous condition because it wasn't marked bike lane, bike lane, bike lane. It didn't have the signs. And they were told by an expert in another case that had settled that that was a dangerous condition that could cause serious injury or death. And they did nothing. So I demanded $50 million. They offered me $30 million, which I just rejected out of hand because insurance was $50. Turns out $30 million would have been then the highest personal injury settlement in the history of the United States, not counting class action or mass torts. So eventually, I just was going to the jury. I'm going to say all they had to do is get a bucket of paint and a stencil and mark bike lane, bike lane, bike lane. On the day of trial, they said, fine, $50 million. So how did that happen? I went to the site. I looked at it. I didn't just say, okay, you got hit by an uninsured hit and run drunk driver. Forget about it. I went and looked to see if there's another way that we can find liability, and I found it.
Love the example. And it just, that's a perfect testament to all the key characteristics you've pointed out with respect to, discipline, preparedness, and really preparing as if you're going against the biggest challenge you've ever gone against. Because in most instances, when you don't have that mindset, you're not taking time to go explore the scene as you've described and doing the due diligence. Dan, thank you.
You're welcome. You're very welcome. That is exactly how I approach cases. And also, I know other lawyers that handle things in similar ways. So one thing you talked about earlier is a service I provide to clients. I can find the right lawyer in the right community and the right specialty for clients throughout the U.S. So right now, actually, I've moved from California to Puerto Rico. The reason being, I am now 1 hour ahead of New York, not 3 hours behind New York, right? So I can still communicate with all the clients and law firms throughout the United States and not be a little bit behind as I was in California. And also, I'm living in a beautiful resort, so not so bad.
Dan, for those who wish to reach out to you, to contact you, what's the best way that they can do that?
A couple ways. There's a telephone number I can give you, and that is 888-570-0000, or my email, dan@callahanconsulting.com.
Perfect. Thanks again for the time, Dan. Enjoyed the conversation.
Tanner, thank you very much. So have I.
Blossom by ConsultWebs with Tanner Jones. For show notes, links, and info, go to consultwebs.com/podcast. Be sure to subscribe and leave us a review. Watch for the next Lawsome episode to discover more breakthrough insights to build a thriving law firm.